Okay, going to the midterm. I apologize, I haven't graded it yet. I was lazy over the holiday weekend. But I'm willing to bet the average grade is about 5, maybe a little higher. You guys are a little better prepared because of how I had the reading assignment set up. We'll go over it briefly next week. I will have graded it by then. You'll have the grades. You can raise any questions. We're almost done here, folks. This week and next. The only assignments you've got left, I think there's one more status report for the Saturday. And then there's a deliverable number 10, which is just an assessment of the project in the class. It's pretty boring. It's a little thing, what went well on your project, what didn't, what did you like about the class, what recommendations do you have for changes. Actually, listen to this. Yeah?
Is that assignment linked on Learning Suite already, or is it?
It should be published on Learning Suite. If not, someone DM me after class and I'll publish it. Anyway. Other than that, I think I'm up to date. I did get one DM just before class saying I've watched the video. I've posted what I currently have out on Slack as far as attendance. And this is pretty important. This actually, you lose 2 points for every class that you haven't made up to a -8 points. So it's worth taking the time to look at the, to watch the, if we're in a class, worth taking the time to watch the videos. Okay, let's back up here. And this is all we're going to talk about today. Any other questions or comments before we get started? Yep. Okay. It's been a pretty easy class, hasn't it? All things considered. Do the reading. It's hard. It's pretty hard not to do well if you just done the reading. Legal issues. This is a lecture I added a few years ago. I was actually originally asked to go lecture over at the IT and cybersecurity department, or program, or whatever they call themselves, on this issue, and thought I should cover this for my own students. And it's an important one because there are a lot of legal issues that will surround the work that you do, that you may not be aware of. Now, I am not a lawyer. This is not legal advice. I have to say that. Because I can get in trouble for giving what appears to be legal advice. But as noted, I have worked in IT for 47 years, and the last 22 I've spent doing work as an expert witness, which means I've dealt with cases dealing with all these issues, and I have seen the mistakes that software engineers, IT managers, other personnel have made in the course of both the events that lead to the litigation or in the course of the litigation itself. So what I'm trying to do here is give you a heads up and say, okay, this is stuff you just need to be aware of. Don't get yourself into trouble because it's really easy if you're not aware. Okay, 6 areas I'm going to cover. Don't need to go through those. Okay, intellectual property. It's been fascinating for me over the last almost 50 years to watch intellectual property become literally a multi-trillion-dollar global industry. It's not that it wasn't important 40 to 50 years ago, but it's nothing like it is now. Everything is wrapped around intellectual property. And because the stakes are so high, as I note here, there's an eagerness to litigate over this. And probably the first thing that dragged IT into it were people downloading music files illegally. The RIAA, Record Industry Association of America, started doing these multi-million-dollar lawsuits against individuals because they downloaded 100 songs, things like that. Yeah. So it's a, and there's been a lot of back and forth, there have been a number of decisions over the past 40, 50 years and so on. But you need to be aware of the types of intellectual property. A lot of you will create these. They'll probably belong to your employer, but some of you may create them on your own. And you need to know what the types of protection are, how you protect them, and how you avoid violating someone else's rights in terms of intellectual property. Patents. Okay, patents we all sort of know, it goes all the way back, literally the Constitution. The Constitution establishes the concept of a patent. The idea of a patent is that if I invent something new, I can file for a patent, and if I am awarded the patent, which is neither cheap nor fast to get that done, then I have an exclusive ownership of that invention for a fixed period of time. And anyone who wants to use it has to pay me a license fee of my choosing. That's very simple. Then the patent expires. Now the idea of a patent is to encourage invention and encourage sharing the invention. That's not exactly how it's worked out, especially when it comes to software patents and patents in IT. Because what you have instead is you have patent warfare. You have patent trolls who buy up what are called non-practicing entities, is the nice name. Someone who doesn't actually make use of the patent but owns them and goes around and finds companies and says, pay up, we own this patent. There are reasons for rejecting patents, and part of the real problem here is that there has been great inconsistency in the courts, including in the Supreme Court, over what you can or cannot patent in terms of software. Just in the last 10 years, there's been 2 or 3 different rulings out of the Supreme Court that have sort of gone back and forth. So, you may, in the course of your work, you may end up with your name on a patent, but it will almost certainly be assigned to your employer. On the other hand, I have a friend who owns a couple of patents all by himself. And it was a long process to do it. And then the problem is, if you own a patent and someone infringes it, you have to have the deep pockets to be able to sue them to do that. And sometimes you can find law firms that are willing to front the money, or actually, and this is a novel development just really within the last decade. You have investment firms that will fund a patent suit in exchange for a share of any payout that comes back. It's basically a risk. It basically says, we will give you $10 million to file this patent suit, and we want 30% of whatever you're awarded. And they do this because they assume that you're going to get a large award, and it's going to be pay back everything that they give you plus a bonus on top of that. Any questions on patents? This isn't a law course, I just want you to be aware of these. Copyright. Copyright, and Congress keeps messing with copyright, for good or for bad. But basically, when you create something, you immediately have a copyright to it. If I sit here and write a poem, I immediately own the copyright to it. I don't even have to put a copyright statement or anything else. The very act of creating your artistic work gives you the copyright. That said, it is good to protect your stuff. If you're writing source code on your own project for yourself, put a copyright statement in the header of the file. If you're writing a book or a novel, I've got some novels that I'm co-authoring, and on our drafts, the footer, we actually have copyright statements in a number of places. We don't need them, it's good practice. You don't have to go to the federal government and file something with the Copyright Office in order to have a copyright. You only need to do that if you're actually going to court. Copyright is a federal statute, which means if I'm suing you for copyright infringement, I have to take it to federal court. And before I can do that, I have to, whatever I'm claiming that you are infringing, I have to go and file it with the U.S. Copyright Office. Now here's the interesting one for what we have here. Non-literal copying. This was pretty much established in Computer Associates, the Altai, where a programmer took a program belonging to Computer Associates, written in one language, and rewrote it in a different language. And then claimed it wasn't copyright infringement because it was different programming language. The code read differently. And the court basically established a mechanism for non-literal copying. You know, I can't take your C# program and rewrite it in BASIC. Or probably can't take your C# program, but rewrite it in Haskell and say, no, this is a new work. I'm not violating your copyright. If you know, I can't do that if you can show that after, well, I won't go into abstraction, filtration, comparison. You can look it up, but there are ways to test. I actually use this a lot. Not just in copyright, I also use it in trade secret or misappropriation of intellectual property, any kind of suit there, where they try to sort of change things up. And it's like, no, really, this is the same thing. This is how it works. Any questions on copyright? Yes?
There are cases of, like, is this any sort of creation, or is it specifically creative creation? And what I mean by that is, say you're using some framework or trying to solve a specific problem, and there's an intuitive best way to solve that, and it turns out that's something that someone else has done before. Like, at what point does it become a problem?
You have the filtration comparison. In other words, if they have a copyright to it, if it's a known solution, and this is the filtration portion. If you have a piece of code that puts up a window in Windows, and I have a piece of code that does the same thing, chances are our code's going to look very, very similar for that portion because it's mandated by external circumstances. So that's part of the filtration. It's like, well, everyone has to do this. And the fact that, you know, even if I happen to use the same variable names, it doesn't matter because I'm constrained by Microsoft Windows. This is not some novel solution you have. Efficiency can also rule it out. You know, if you have copyright code that's got a binary search in it, and I implement a binary search, you can't come after me. It's like, it's public domain, everyone knows binary search, and it's an efficiency issue. If it's the best obvious way to do it, you can't get it for that reason. So there are a number of filtration things that will rule it out. You know, is it in the public domain? Is it generally practiced? Is it efficient? Is it mandated by external circumstances? Is it part of what in literary copyright, what's called scenes à foi, meaning common scenes. If I write a novel about a hard-boiled detective with a dame who comes in with a thing, and, you know, I'm drinking booze out of the thing, those are all tropes. Those are all common things in a noir mystery. And you can't sue me because you didn't use them in your noir mystery that's copyright, and I happen to be using them as well. Well, the same thing basically happens in software. If I'm writing word processor and I put in a spell checker, Microsoft can't come and sue me and say, oh, we have a spell checker, you're violating our copyright. It's like, no, everyone has a spell checker. True fact, I helped write the very first embedded spell checker for Microsoft Word. Spell checkers used to be separate programs, and I worked for Oasis Systems, same place where I did Sundog. We did word processing utilities. We had an industry-leading spell checker called the Word Plus. Microsoft came to us and said, we want to integrate this with Microsoft Word. So I had to interpret. They gave us their file format, and I had to interpret all of it, and then Wayne had to actually modify the code and embed it into Microsoft. That's neither here nor there. Yes?
So with the example of a spell checker, the concept of a spell checker is pretty ubiquitous at this point. If there's someone who develops some sort of interesting and creative way to approach the concept of identifying and correcting misspellings, would that that doesn't seem like a copyright thing, that seems like more of a patent thing.
Well, yeah, they could try to patent it, but again, there's a lot of complexity as to what you can actually patent in software. It was sort of the wild, wild west out there for a while, and people were patenting everything. There's at one point an issued patent to patent using exclusive OR to draw and erase on a screen.
Well,
And this is after people had used it for years, and people it got overturned.
I'm asking these questions because I'm getting the general feeling of being in the middle of a minefield, and I'm probably fine until I'm not.
You're probably generally fine, and with copyright, again, patent is very clear because they have to have an issued patent. Copyright is pretty much protects source code and an attempt, if you get access to the source code and you re-implement a different language, then you can be found with this non-literal copying. If you don't have access to the source code, you can't violate copyright. And there have been a number of decisions, they were sort of conflicting on copyright of look and feel and user interface. And there's some complex law there, but stop and think. I mean, how many of you play games? Okay. WASD. Everyone uses WASD. Actually, it goes back to word processors in very early days. But there are other tropes, you know. Well, you do this for sprint, and you do this for crouch, and you do this. And for end users, frankly, I'm grateful when I'm picking up a new game. It's like, oh yeah, okay, this is just like such and such. You know, this works just like Tomb Raider, so I know how to do this. And it's when they change everything, it's like, you know, okay, let's remap the keyboard because I already know how I want to do this. So it's not often a mine unless you're really leading edge, and even there, it's going to be hard for them to make a case against you, unless there really is some form of misappropriation. That's the basic thing is avoid misappropriation. Almost all of my copyright cases are one or more programmers leave company A, they go to company B, or they start up company B, and they start doing the same thing they were doing at company A. And company A says, wait, you just walked off with, you know, intellectual property. Be it source code, be it, you know, trade secret, be it whatever it is, you're walking off with confidential information, recreating over there. And I've had cases where it is truly a violation. I've had cases where no, there's no violation there, but they sued to basically find out that there was no violation there. Any other questions? Trade secret, trade secret. Coca-Cola recipe is a classic trade secret. Trade secret is the opposite of patent. You have to hide, you have to take, it has to be valuable, and you have to take sufficient pains to maintain the confidentiality of the trade secret. In software terms, this could be you have some nifty algorithm which allows you to do X in a way that no one's done before. You can choose to try and patent it, though that's iffy. Your trade secret says we're not going to tell anyone how we do it. This is our secret sauce. It's hidden inside. Now, trade secrets can usually be reverse engineered. A lot of what you've had here are licensing agreements so that people will not sell you their software or their technology unless you agree to a licensing agreement that says you cannot reverse engineer things. I mean, the simple truth is, if I have object code, I can decompile it, I can look at the assembly language, I can probably figure out your algorithm. So the protection there is you have a licensing agreement that says you cannot own our software unless you have executed this license agreement, and the license agreement prohibits you from doing that. But for something to qualify as a trade secret, it has to be valuable. It has to have value by virtue of not being known. In other words, I can do something and you can't do it, and I have a competitive advantage because of it. I've spent time and money in developing this trade secret, and I have made reasonable efforts to maintain secrecy, which means confidentiality agreements for my employees, secure network for the source code, so on and so forth. Any questions? And I do a fair number. I'm in the middle of a couple of trade secret cases right now. Yeah.
So something becomes a trade secret by meeting those qualifications, not by like filing it, not by any
No,
legal.
you don't. Ideally, you don't tell anyone. But if you have reason to believe someone has misappropriated your trade secret, you're going to have to show that in court. Basically said, no, they had no right to this. They had, this is where you go to the misappropriation. We can show you there's improper access and/or means in getting to this trade secret, and that you subsequently made improper use or disclosure of it, and then I can sue you. This is why as you have jobs, you will have things like assignment and invention paragraphs, which we'll talk about in a minute, in your employment agreements that basically say we own what you do, and you can't turn around and disclose what we do. It's the basis of non-competes, which we'll also talk about in a minute. So it's the whole value is that you don't tell anyone about it. It's like, hey, we have this nifty new software, and who knows how we do this magic thing. Yeah.
So then, in the litigation itself, how do you go about proving it was a trade secret without disclosing the trade secret? Do you just like?
Well, no, you have to
close
disclose
doors?
the trade secret. Basically, everything's done attorney's eyes only. I have, with the current trade secret case I'm working on, I had to put an electronic lock on my home office door and have a safe to hold the source code from the other side that I was reviewing. Now, the irony with that is they really haven't been able to define a trade secret, and my standard comment to the lawyers I'm working with is they could post this out on a public GitHub and no one would look at the source code twice. But they're claiming this is all trade secret. It's actually, well, I won't get into it because it's an active case, but anyway. But no, in fact, I've had cases. I had one trade secret case that on my resume of cases I've worked on does not name the parties, but simply says filed under seal, because the two parties moved to have their names filed under seal in the record because one was looking at buying the other, and they still to this day don't want anyone to know that was something that went on. So usually what you have is, you sign protective order, and this is one of my pet peeves because I've done this for 22 years. 90% of my cases, I sign a protective order, they send me a hard drive, I do the analysis and so on and so forth. But I've had 3 or 4 cases where the other side has been, no, this is greatly valuable stuff. The worst was a case I worked on that involved algorithmic trading source code. I literally spent 2.5 months in north of Los Angeles and had to go into the secure facility that I couldn't bring any notepads into to actually review the source code. And of course had signed, non-disclosure and protective orders up the wazoo on that. The biggest problem in the trade secret case, quite frankly, is defining a trade secret. Because what you often have is the plaintiff says, oh, this is trade secret. I said, okay, what is a trade secret exactly? And they're like, oh, well, it's this and this. It's like, well, no, that's not really a trade secret. You're just saying, this is stuff we wrote. What is actually has value, is subject to reasonable efforts, and is not readily ascertainable. A lot of trade secret cases fail on those 3 points up there. Any other questions? Yeah?
So when is reverse engineering okay?
If you're not specifically enjoined by it, in other words, if you have access to the object code or to the operating item itself, and there isn't a license agreement. Now, part of the problem is Congress does a remarkably poor job on passing litigation involving information technology. They passed something called the Digital Copyright Millennium Act, which basically allowed a lot of companies to say, no, you can't, we have protection in here to prevent you from reverse engineering, and you can't bypass it. And there's been a mix of, I can't talk to the current state because not many of my cases involve the DCMA. But there have been conflicting rulings as to what is or is not allowed. A classic one of this is printer cartridges. A lot of printer manufacturers have put things in to basically say, you know, we won't recognize anyone but our own cartridges, and then cartridge manufacturers say, oh yeah, we can we can reverse engineer this and do it. There have been some lawsuits back and forth, and you know, the manufacturers have won some, and the third-party cartridge makers have won some. I don't know where things stand currently. Any other question? Yes.
You mentioned how, like for like job applications, and for when you're signing contracts, they require that you
Yeah.
put a list of different like kind of
Things you're working on. So,
yeah. So is that like saying, hey, these are things that I'm working on like outside of work that I am going to keep proprietary on, basically?
We'll talk about that in a second.
Okay.
That's actually a whole other discussion here. Any other questions on trade secrets? Okay, licensing. How many of you read your EULAs, end user license agreements? Yeah. Yeah, it's kind of like click and agree. Yeah, whatever. A license is a grant of use under mutually agreed upon terms and conditions. There are actually limits. And there have been some court rulings, some legislation back and forth as to how binding EULAs are, particularly since they tend to be long, complex, and not readable by the average consumer. It may bar, as noted here, it may bar reverse engineering, use out of scope, derivation, specific application. The software industry, the movie industry, and the record industry are very vigorous in pursuing license violations. And they seek big awards. The courts have courts originally were granted big awards, and they've sort of backed off of that, and there have been a number of court rulings. For example, there were some early cases where imagine you're in an apartment, there's a specific IP address that goes to your apartment, you're sharing with 5 other people, and the Record Industry Association of America, RIA, comes and sues you personally because there were 100 songs downloaded and they want $100,000 for each of the 100 songs that you downloaded. And they say, well, you're at that IP address. And courts originally were actually allowing that. And there have since been court rulings that say, no, you know, you can't identify a person just because of an IP address that ends at their domicile. So short answer is you know, don't violate licenses. That's the best way to keep safe. And fortunately, competition has gotten such that companies are more willing to make things more reasonable. Apple started off, for example, with their music, started off with some very strict licensing and so on and so forth, and they keep relaxing things. They're still a bit onerous, but I don't buy stuff from Apple as a rule. Anyway, any questions here? This usually doesn't tend to affect you professionally. Just be aware that it's possible if you're downloading a lot of stuff illegally to get into trouble. Yes?
When it comes to licensing for software projects, I've seen a number of different licenses, like the GNU public license, LPL, MIT, etc. In general, are these licenses just, I'm guessing there's these pre-made licenses that we can just tack onto the top
And
of our
you're talking
source code.
specifically about some of the open source licenses.
Right.
Yeah.
So like, I guess there's those template licenses that we can just stick on our source code, and it's available for our use to protect our stuff. But then we can also, as developers, make licenses for the use of our product, which is separate from the licensing of the source code.
Yes. Well, usually, if you're using a public source license, something like GPL or something, it's because you're actually, you either you want to put your stuff out there for other people to use, but you just want to, you're basically saying, yes, you can use what I've written, but if you do, you have to make your source code available as well. If you're putting it out there, if you're doing a commercial commercial product, you really don't care about a public source license. You're looking at selling stuff, and so you want terms and conditions for anyone who's paying you money. You're actually having them pay you money for this. So there are a number of options there. Any questions here? Okay, agreements, and this gets back to some of the questions you had. The agreements can be one-off. For many years in the 80s and early 90s, wrote for a number of computer magazines, Byte and Macworld, and a number of others. And I would guess during that time, probably signed easily 100 NDAs because I was getting product previews of things that had not been released yet. So I could write about them so that the article would come out at the time the product was actually announced. With companies that are doing business together, right now, my close friend and colleague Bruce Henderson and I are doing some work for actually a company based out of Utah County here. And we signed various NDAs and other agreements to basically say we will hold this engagement confidential, and anything we learn we will not use, so on and so forth. And employers. Now, it used to be that, frankly, when I started 43 years ago, after I graduated, employers were actually far more lax. They just hired you. Now everyone has you sign an employment agreement. Always, always, always read your employment agreement carefully. And even if they try to tell you, oh, we don't really enforce them, don't buy it. Because if there's ever a litigation, yes, they will say, oh yeah, this is enforceable, you signed this. My description is you should read them as if you're doing a code review looking for bugs. And you will find that as a software engineer, you're actually very good at reading legal documents. Because you'll read what they say and you'll say, well, wait, what about this condition? What about this one? What about this one? When I was at Pages, we were signing, we were drafting licensing agreements for outside customers, and I would review them and I'd say, look, we have a problem here. We have just committed to this, or this says that we're going to do X, and I can tell you we're not going to do X, at least not in this time frame. So read anything that you're given to sign carefully. You want everything as clear as possible, and you want everything in writing. Any questions? We're going to talk about some of these specific items like non-competes and so on, but yes?
Are there limits to agreements, or is anything that you sign automatically enforceable?
Well, and this is getting into contract law, and I'm not a lawyer, but my understanding is that, yeah, there are limits. If they talk about indentured servitude, there are things that the court will say, no, this was not a reasonable term with this interpretation. But if you're talking about, issues with intellectual property and so on, be real careful about what you sign, because you may be limiting yourself on that. There's a question here, yeah.
What if you have a serious problem with what you're reading? Should you just not accept the job, or
be willing to walk away? This is remember, something I said early in the class was that the only way you can affect change in an organization is going every day prepared to be fired. It's like buying a car. If you're not willing to walk away, you're going to get taken by a good car dealer. You have to be willing to say, no, this isn't acceptable. And part of it is they're going to put the best possible terms for them, and you look at it and say, no, these are the changes I need. And if they're not willing to change, then be willing to walk away. because that really is your option. Otherwise, you're signing and agreeing to the terms. Now, I did a column for Baseline magazine, for the online version of Baseline magazine, back in the late noughts, like 2008, 2009. In fact, a lot of the articles you read here were originally written as columns for there. And the first agreement they sent me was, and literally the language said, we own all your rights across the universe. They used that phrase, across the universe, forever. And I laughed and wrote back to the editor and said, no. I said I wouldn't sign it. It said, but I retain all copyright. I said, okay, sure. So, you know, basic, if there's anything you don't like, push back. And if it's a job you really want and you're really concerned, consider finding a lawyer and having them, you know, paying them a couple $100 to have them review it and say, here are the pitfalls that may be in there. Yes?
So how does that apply if, for example, I'm working for a company and I sign an NDA or, you know, a contract, but then I freelance outside of work?
Oh, God.
So, yeah, okay.
Okay. Do not do that unless you have a prior agreement with your employer that you can freelance.
Okay.
And we'll talk about that again in a second. But yeah, you do not. There is case law that basically a lot of companies will have explicitly. I had a student last semester before, had an internship at, I think it was Amazon. Basically said, we own everything, including anything you do on your own time, on your own equipment, while you're working for us. A lot of companies will take that as a starting point, and you basically have to negotiate back from it. Most companies will not accept you freelancing. They will consider that a firing offense. And they will consider it possibly a breach of intellectual property rights. In other words, they'll put the onus on you to prove you were not making use of things that you learned or were learning at your employer while you were freelancing. You know, if you want to freelance full-time, but if you've got a full-time job, freelance only, but if you've got a full-time regular employment, don't freelance. It's a legal nightmare. It's a minefield. So, anything else? Well, we can come back to some of this because I still have several things with employment. Non-compete. Most states allow non-compete. Most famously, California, both in the legislature and the judiciary, has taken a stance of the least possible restraint on non-compete. It really has to be theft of trade secret. Otherwise, they can't do anything. They can't prevent you going. Which is why you have these people who bounce back and forth from Google, Apple, or Facebook, or whatever. And if there's a lawsuit, it's a misappropriation. It's not a non-compete. It's a misappropriation of intellectual property. You took stuff along with it. Which amazingly and stupidly has happened. It's like, oh yeah, I'm going from Apple to Google and I'm taking along source code. Part of the problem with non-compete, and I'm going to skip ahead here, is that it's the darker green, the more they're willing to enforce non-competes. It varies from state to state. Utah is actually pretty good. But don't assume, don't sign a non-compete and say, yeah, they can't enforce it anyway. Because you may find yourself in court. And you may eventually prevail, but you may end up with, a couple $100,000 in legal fees in the process. So, always ask about non-compete. Always don't accept verbal, oh, well, we never enforce that, or no, you'll be fine. No, get everything in writing. Ask about using an NDA instead of non-compete, which is really the issue, because the problem here is that if I'm really good at, say, word processing, which I was once upon a time, 25 years, but I was chief architect for a desktop publishing system. And I wanted to leave Pages while it was still going on. What's my most valuable thing? It's to go to another company and say, yeah, I know how to do word processing. And if I'm under a non-compete, it's like, well, if there's nothing to do, I was in California, so they couldn't stop me much anyway. But basically, these last 2 points are things that I have seen. First, see if you can do an NDA instead of a non-compete, so they can't restrict who you go to. They simply restrict what you can share from what you learn at the company. And the other one is make sure it's as short a time limit as possible and an explicit list of companies. Not, anyone we deem a competitor, because I have seen non-compete cases where it's basically a form of legal harassment. The company, the person who's going to really isn't a competitor, but they are saying, no, you're competing. We deem them a competitor, and therefore you have to abide by this. And then, as I said, it really varies from state to state. I've seen people online saying, oh, no one enforces non-competes anymore. No. There are states that will enforce non-competes and will enforce like 5-year non-competes. And there are states that will enforce, even if they don't have non-competes, will enforce non-competes from other states. So be very careful with that. Yes?
Sorry, I'm trying to think of like how to word this question. So I signed, maybe I shouldn't be admitting to this, but I signed a contract with a company this last summer, and I found several clauses in it that I found somewhat questionable. And so I went and approached the lady who was in charge of it, and she was so clueless. And I was like, I don't know what I do, because she's like the head of human resources at this company, and I'm trying to get...
They probably got boilerplate from somewhere. She probably is truly HR, has no legal understanding of the issues of those. And what I, knowing what I know now, what I would do in your spot, or would have done, is simply say, can we rewrite these clauses this way? And let them see if they're willing to say it. Because if they're really clueless, they may say, well, yeah, that sounds fine.
Okay.
That can be an advantage. It's like, oh yeah, well that sounds reasonable. No, seriously. It's like the across the universe thing. It's like, are you guys kidding me? I'm sure someone stuck it in there saying, yeah, we'll just start this with a baseline and negotiate from there. And immediately folded when I said, no. I'm not signing that, and I want all copyrights after publication. I said, okay. Because they needed me more than I needed them. Non-work projects. Okay, this is what a lot of you are doing. You have your own at-home projects, startup. As noted, your employer may try to claim anything you do before you sign your employment agreement. What you want to do is say, here is a list, here's a written list of my current and anticipated outside of work projects. I will only work on these on my own time, with my own equipment. Is that acceptable? If they say no, then you get to decide whether or not you're going to work on those anyway, I mean somewhere else, or you're going to take the job and not work on it. And I can't stress these last two enough because, I mean, literally folks, literally, I won't name the parties, but I sat in on a deposition of a developer who was planning to leave his current job with 2 other people at his current job and start a new company that his old company claims competes directly against them. And during work hours on work equipment was doing editing, doing check-ins to GitHub on both his current employer's source code and the source code for this new company. He literally, on the same machine, had both sets of source code because he had his local copies and then was, committing stuff to the GitHub repository. I mean, and we basically got him to admit that. And then he did it with his own personal computer because he was doing some work with them. He bought his own MacBook and was doing some consulting work for his former employer as a consultant, and again was, grabbing copies of source code, making changes, and committing them for this former employer while he was working on source code and had both sets of source code, competing products, source code on the same computer, on the same physical hard disk. That's absolutely appalling. Don't leave with company source code. Don't leave with anything from your company. I used to, 45 years ago. I still have source code. Actually, I have most of the source code, not all of it, but most of the source code for Sundoc. But I used to walk out with source code things. Oh no, never do that. Never do that. Again, a case I worked on several years ago. Small company doing database management tools for IBM DB2. Big company, Computer Associates, again, comes in to buy them up. 5 of the developers for this project don't want to work for Computer Associates, so they go to another company called Quest, not the telephone company. It's another DB or another database management tools company. Unbeknownst to Quest, one of the 5 developers brings with him a CD-ROM of all the source code they've developed to date. And about a year or 2 later, one of those 5 developers who've gone over to Quest doesn't get the promotion he wants. He quits, then writes an anonymous letter to Computer Associates and says, by the way, Quest has your source code. One of the guys who came out of Paragon took it with him. And CA immediately files lawsuit, preliminary injunction, brief, and so on against Quest. Quest hires me and says, we need to know if the source code is anywhere. They found the programmer who took the source code, he fessed up, gave him the CD-ROM, says, we need to find if any of his source code is in our shipping product. This is back around early 2000s. 3 million lines of source code, 5 million lines of source code. I wrote some custom tools to do fuzzy comparisons so that basically looking for matching roots of identifiers, because you had a lot of identifiers that had the original company's prefix and so on, and in the new company they had a new prefix for them. I actually had to go out and buy 2 other computers, and I had this program running night and day for about 2 weeks. Sure enough, I found a series of identical comments. Identical comments are an absolute killer in source code copyright, more so than matching code. Because you can explain the matching code in terms of requirements, efficiency, and so on. When you have identical comments, it's like, yeah, there's no way those identical comments got in there in the same order, in the same section of code. And there was about 10 or 20 identical comments. And all he had used was he had some Lex and YAC files that were used for the syntax for SQL for DB2, IBM DB2 database. And he saved himself about 2 weeks of work by using that. And that was all that he used out of the stuff he brought. And it was a multi-million-dollar lawsuit as a result. Don't walk away with source code. Just don't do it. Yes?
So presumably he was the one that was liable for that, not Quest.
Well, actually, the company was shipping it in their, this was in their shipping product. So I identified it and immediately started a clean room reverse engineering effort with developers that they could prove never had any access to that source code who rewrote that whole section of code and a lot of stuff around it. So by the time it actually came to a preliminary injunction hearing, Quest could say it's no longer in any shipping product. We did this clean room reverse engineer. We have pushed out this new version to all our customers. There's no longer any running version out in the market that uses this and so on. And they finally ended up reaching an agreement with Computer Associates. Yes?
The employee that did that like end up on, I don't know, a record somewhere so companies knew that he
Well,
did
his
that?
name was on the lawsuit, so yeah. And he wasn't financially liable, and Quest, of course, didn't want to fire him while the lawsuit was going on because he could turn around and start basically be used as a witness by the other side against Quest. So they basically paid for all his legal fees and legal representation and so on. I honestly don't know what happened once the lawsuit settled, but I suspect they fired his butt. Yes?
So as a company, how can you ever protect yourself against one of your employees doing something that's stupid? Like,
You can't. You can't. You could. This is a landmine. If you hire someone from a competitor they bring in source code and you don't know about it, you need to have some pretty rigorous screening. I'm working on another trade secret case right now, where the company I'm working for actually has some pretty rigorous separation of development groups and checks for, are we bringing in inadvertent intellectual property from elsewhere. But this is literally a global company that I'm talking about. Quest was a relatively small firm. They had no reason to know, understand, or suspect that this was going on, and really never would have known about it if it hadn't been in the anonymous letter. Yes?
Could you include in your employee agreement, making them sign that they won't use like code from somewhere else?
Yes, yes. And I suspect, actually, I would not be surprised if a lot of employee agreements have clauses like that you basically represent that you were not misappropriating or bringing in outside intellectual property that you do not have rights to. Yes?
Is there anything you can't take from work? Like I've been in some internships where they set aside 4 hours every week where you get to learn some new design pattern or programming concept, and you get to take notes and learn from that. Are you allowed to take
Literally, you need to talk to the company. Say, what can I walk off with? And in many cases, they won't care. But it's something you need to explicitly bring up and say, what can I take with me? And then adhere to whatever you end up agreeing to.
Yeah,
Any
it's
questions? Let me move on. Unauthorized access. Congress, in its wisdom, passed the Computer Fraud and Abuse Act back in 1986. This has been, like the DCMA, this has been something of a legal nightmare because it is so vague and it has such harsh penalties. The idea, this was back in the era where hackers were a big thing in the mid-'80s. It's like there are hackers who were breaking into companies. And Congress said, we need to do something and we're going to pass this. And it penalizes, it criminalizes access without authorization, but does not define what without authorization means. And the penalties are very harsh. I don't know how many know the story of Aaron Swartz. Aaron did something that was illegal. Basically, Aaron felt that a lot of academic journals keep their stuff behind paywalls, and he felt this was a bad thing. So he used his position at MIT to use MIT's subscriptions to get academic articles from behind paywalls, and was posting them on this server at MIT that was publicly available. And he got found out. He was arrested. And under the CFAA, the prosecutor was asking for 35 years in prison. And Aaron killed himself rather than go to trial. The short answer is be careful where you go and what you do. It can be fun to sort of poke around. I used to, I worked at the Lunar and Planetary Institute, and we had one dial-up modem. Of course, we're talking, 80, 81. So it's remarkable we had that. But we had one dial-up modem so that you could get access from outside to the computer network, which was a VAX 11780. And of course, as programmer there after I left, I amused myself by going in and calling the number and getting online and browsing through the network. This was all before the CFAA, so it wasn't technically illegal. But and Roger Phillips, director of the institute, was fine, so he's probably like, yeah, I'll look around first. Can you fix this for me while you're at it? you need to be very careful. Here is this is a current case before the Supreme Court. I don't think this has been decided. And basically, part of it involves access that you are not entitled to obtain, and also terms of service that can say you can be penalized for posting false information and basically putting false information. Now the idea there is you don't want someone hacking into your accounting system and changing the values here. But under the current interpretation of the CFAA, as noted in this, inflating one's height on a dating site is a federal crime. Because you're putting false information on this website. The CFAA is a nightmare. I'll say that quite bluntly. Badly drafted, badly expanded. I'm hoping that some of the court cases are going to significantly constrain it. But it really is something of a nightmare, yeah.
So for the group projects,
Yes.
I mean, our group is Ultimate Werewolf, which is an existing game that you have to pay for, and thus I'm pretty sure we're breaking copyright if we were to ever publish it, which wasn't my plan at all. I don't know if anyone that. I think Valeria is also in a similar boat.
Yeah.
I'm just curious, are we like subject to being, sued to death?
Not unless you try to sell it.
Okay. But
If you try to sell it, they'll come after you. If you simply put it up publicly, they may send a cease and desist letter.
Okay.
But in a lot of cases, companies are like, yeah, this doesn't really matter. It's just going to make, what they have out there is actually kind of crude. It's just going to drive people to our product.
Okay.
Here's the one that I find tremendously fascinating. How many of you go to FanX or any of the comic conferences? First time I went, I looked around and said, how are all these artists doing and selling drawings, sculptures, and so on of copyright figures without paying licensing fees? And it's a very interesting gray area. Basically, even Disney, who's notorious for sort of takes a bit of a hands-off approach. It's kind of like, yeah, you can do this, within the context of Comic-Con and so on. You can get these great pictures and various things. But if they chose to, they could write, 300 cease and desist letters and basically shut down all these artists and say, no, you can't ever do this in character of any kind again. So with Werewolf and Valeria, it's one of the reasons why, for example, if you see knockoff games, they'll just change the name slightly, and the concepts, the game concepts themselves are usually public domain enough that you can't quite protect them. Anyway, did you have?
Yeah, just, I guess, changing the name would fix it, but like, if I were to post something like that on a personal server that was available publicly on the web, the worst that could happen then is...
Worst that happens, you get a letter from their law firm saying, please cease and desist.
And then I just turn it off.
And then you just turn it off or you change the name.
Everyone's happy. Okay.
Yeah. Luke de Garou, something, Werebeast. Seriously. You see stuff like this all the time. Speaking of which, and yet there are places that aren't even that subtle. One case I worked on as a neutral expert had to do with a bubble game for mobile phones. And the original manufacturer was out of Sweden, and they found this Chinese game that they said, we think this is a ripoff. And both law firms basically said, we're going to use you as a neutral expert, do the analysis, I'm going to send you the source code and all the data files and so on, and plus the working programs. You can look at them, and we'll basically take what your findings are into it, okay? And it was pretty clear that the Chinese game was largely rip-off. I mean, the names were changed, but it was largely rip-off. But here was the damning portion for the Chinese game. The Swedish game had in its data files a number of levels that were in the data files but were not accessible in the game. They had been designed, but you simply, there's no way to unlock them, no way to get to them. The Chinese game had those same files, or the same levels, which meant that they had decompiled and actually copied over levels that you couldn't even get in the Swedish game from the Swedish game. So that sort of shot down the defense on the Swedish part. And the irony there is that the law firm that actually originally approached me about being a neutral expert was representing the Chinese firm. Because I've worked with one of the lawyers there before. I'm not sure he was happy with my findings. Anyway, yes.
Do companies ever put like bogus lines of code in the source so that if somebody takes it and uses it, they can like say that code doesn't actually do anything, but how did that?
Oh, well, it's usually not lines of source code. What they'll do is they'll put data streams in there because, you know, the source code compiles down to object code.
Mm-hmm.
And what they'll do is often a number of things. First, they'll often compile copyright statements into the object code. But beyond that, they'll often put things in that are bogus or very specific and so on that they can search on and say, okay, are they using our object code? You know, is this embedded in here? Now, if it's a reverse engineer, that's not going to happen. But if someone's actually like grabbing DLLs or stuff like that, you can detect and say, yeah, this is something we built into there. Anything else on this? Yes.
So what's the gray area with emulators where you have an architecture that, you know, might have been implemented in hardware, but then like 20 years later is done in code?
What's usually the area of contention with emulators are the ROMs. Most emulators will require a ROM, and so for example, Macintosh emulators and Apple II emulators were out very quickly, and people would publish emulators and say, yeah, and you need a copy of the ROM to do this, and it's up to you to find it. Of course, other people would post ROM images, but they would post them sort of, you know, at arm's length, sort of, yeah, you can just go to this file here and get this ROM. With age or time, the companies tend to care less about that, again, unless it's an actual financial threat to what you're doing. And of course, this is how IBM clones came to be. When IBM first shipped the IBM personal computer, it had an 8K BIOS, basic input-output system. That was a series of calls, and this is how you talked to the disk and talked to various things and so on, and that was copyright. And this little startup in Dallas called Compaq did a clean room reverse engineer. They basically wrote a paper specification saying, here are the calls, this is the result. And they got a group that had zero exposure to the ROM and the IBM PC and said, write code to the specification, it has to fit in 8K. And they did, and of course IBM sued them, and they went to court, and the court said, no, that's valid reverse engineering. And that's what created the whole market for IBM personal computers. If Compaq had lost that case, then we wouldn't have IBM clones. And frankly, it would have crippled the personal computer industry. I haven't watched it, but I understand the series *Halt and Catch Fire* pretty much follows the plot line in terms of time and history of the creation of the first IBM clone. Okay, troubled failed IT projects. Okay, you guys all know this. That's what we spent the whole semester talking about. And you just spent your thing answering. Here's my recommendation. With all you know now, when you see problems, raise them early and often, even if people don't want to hear it. You know, raise your hand. I've already told you the story about, you know, the identifying the 13 risks and then 6 to 8 weeks later going back and saying 12 to 13 have come to pass. And the project did eventually fail. You'll feel a lot better if you identify, people may not like it or recognize it. But on the other hand, if the projects fail, you may want to start looking around and getting a graceful exit before things crash. Now, what you need to, any questions on this? I mean, you guys know this stuff cold. Yes?
This might be a silly question, but So sometimes with these IT projects, it's like contractual agreement between companies. Would a developer ever have like any legal liability for not raising issues that they knew about?
That's a good question. I have never seen that. You know, it's pretty much, most lawsuits tend to be breach of contract. And the contract is not between the developer and the customer. The contract is almost always between the developing company and the contractor, as opposed to any individual developer. If you as an individual developer were the one who signed the contract and you were that party, then yes, you or your company would have that liability. But I'm sitting here, I can't recall a case where they actually went after an individual developer. And in fact, as I've said before, when I'm acting as an expert witness, one of the most important things I want to see all the emails by the developers, because developers tend to be brutally honest. And it's like, oh yeah, you know, it's as I think I already mentioned, one of the first such cases I worked on, the lead developer, or one of the developers saying, I can't believe we're charging the customer $100,000 for this garbage we're delivering. My experience is engineers tend to be brutally honest, in among themselves and often with management. They're often the ones raising the issues with management. And so I really don't, you know, like I said, unless you personally sign the contract or it's your company, no. I've never seen them come after an individual contractor. Now, what you do need to be aware of is the whole issue of preservation of files. This is a big issue in litigation, period. In essence, when civil litigation starts, one of the things each party is obligated to do is to produce to the other side all relevant documents, and you have discovery requests by each side against the other. When I started, this was all paper documents for the most part, but now it used to be a big deal if I had 1 million files. Now it's like that's no big deal. That's sort of common. So you know, you have to do searching and so on and so forth. But the important part here is that once there is, you don't even have to have litigation start. You simply have to have the threat of litigation to be sufficient that you need to start preserving things. And the key case here was one with American Home Products. They had a product back in the early, actually I want to say late 90s, called FenFen, which was a weight loss product. And it was discovered that there was an incident of pulmonary hypertension developing when people taking FenFen. And litigation took place. Okay, American Home Products, so we're talking late 90s, so this is like before any of you were born in terms of technology. How many of you were born in 1995 or earlier? A couple, okay, one or two. The IT department at American Home Products had a 4-month cycle of backups. They would back up their email and document servers to tape on a monthly basis, and they would, but they only kept 4 tapes, so they would rotate through. I actually did this back at Modern Labs here in the 80s, same thing. In other words, at most I would have 4 months of backups. Well, no one told the IT department to stop rotating stuff. So in a period of 4 months, they basically overwrote stuff. And of course there was older stuff that was there, but there were files that were destroyed as a result. And the judge issued a finding of spoliation, which basically told the jury, you are to assume that American Home Products did this deliberately to destroy bad evidence. And it basically put, the jury found against American Home Products, issued a big reward, and literally American Home Products went bankrupt. So your employer will have retention policies. They will have some automated stuff, so they may have stuff to say delete your email automatically after 30 days, unless you need to save it. And when litigation starts, this is also what put one of the big 8 consulting firms Anderson Consulting, out of business, was that this is over the Enron scandal. They started shredding documents, and they didn't have the retention policy in place to justify that. And again, they were found to have actually deliberately destroyed documents, and there were, I think, criminal charges filed as well. So, the thing to be aware of is that two things. Anything that you keep may be subject to discovery, including emails and files that you may be keeping on your personal laptop that are for work. So, if there's stuff you don't need, get rid of it. And we're all pack rats. We want to hold on to everything. I have a whole plastic bin filled with hard drives with files that probably go back easily 25 years. And I keep swearing I'm going to set up a file server and do deduplication and get everything there. I mean, I have Word files I can't open up under Word because they're like from Word 2.0. But anything you write that gets preserved somewhere can and will be used in litigation. It may be discovered. There's a variation on the old thing, you know, sing as if no one's listening, dance as if no one's watching, and write your emails as if it will be read to you in your deposition. Because that's what happens. Trust me, I've sat in a lot of depositions of people and had, Mr. Jones, did you write this email on this date? Well, yeah, that's my name on it. And you said this, didn't you? Well, yes, I did say that. Emails are very potent in litigation because they are time-stamped. You know who wrote it. You know who it was sent to. And they're usually preserved. Any questions here? Okay, so the simple truth is that there's a lot of fuzzy areas in legal issues in IT. Just tread carefully. In all my years, I've never been sued. I've never been involved in a lawsuit in terms of as one party or the other in actual litigation, only as an expert witness. But be aware of these issues. This is probably a great set of slides are already out there. Great set of slides to copy and take with you, and each time you change jobs, go through it and say, okay, how many of these issues apply? What do I care about? And what am I going to do about it? Any last questions on any of this? Okay, next week, it's your final demos. Hope you're all cranking away on those. And then I have my last lecture. And that's it. If you have classes to make up, DM me. I'm mostly caught up on those. Like I said, one came in just as I was getting ready to leave. Yes?
Attendance?
Oh, thank you. Yes, I need to take attendance.